hello and welcome everyone. I'm very happy to see you all, especially that this is a morning session before the first coffee break, so without caffeine, it's always a bit of challenge. But we have a fascinating topic to discuss today and a great panelist, and I think it would be just a perfect start of the second day of CPDP. So welcome everyone to the panel about practitioners' perspective on the new digital framework in the European Union. And this panel is organized by CPDP, so also thank you to the organizers for putting us together in this beautiful new venue. My name is Nina Baranowska, and I have a pleasure to moderate this session today. I'm a legal scholar. I work as a researcher at Radboud University in the Netherlands, and I'm currently involved in the research and development project on AI in recruitment. And I must say that from the researcher perspective, this is really fascinating to be able to analyze this cluster of new laws coming from the European Union. But I'm also aware that as legal scholars, we are sometimes in a more comfortable situation because we don't have to advise clients and we don't have to take responsibility how these new laws should be implemented by companies. So in this panel, we would like to take a practical approach and look at the EU digital framework through the lenses of practicing lawyers. So we will listen to different perspectives of our experts, and at the end, we will have a Q&A session with the audience. So if you have any comments and questions, there will be time at the end to address those. And I would like to introduce our experts who will share their perspective with us. Just next to me, Erika Aline. She is an ICT and data protection managing associate at Altius law firm, and she's based in Brussels. Then Charles Elleput is a partner and a head of the EU data privacy, cybersecurity, and digital assets practice at Squire, Patton & Box, based in Brussels and Paris. Next to him, Berend van der Eyck is a partner in the international data protection and data regulation practices in Bird & Bird, based in The Hague in the Netherlands. Next, Caroline Michelzin is an attorney and a senior associate in a Stevie law firm based in Brussels. And Laura Brodo is a senior associate in the EU data regulatory practice and at Wilson Sonsini, also based in Brussels. And all our speakers are experts that have been specializing for many years in legal aspects around innovations and data protection. And I assume that they now have much more work because over the past few years, the EU has been consistently implementing the digital strategy. And in a kind of relatively short period of time, we have the new package of new digital laws, including Digital Services Act and the Digital Market Act, which aim to create a safer digital space, but also to increase competition. Then we have Data Governance Act, which regulates voluntary data sharing, and we have Data Act, which clarifies who can create value from data and under which conditions. And finally, we almost have, just behind the corner, the AI Act, which is the first comprehensive regulation on AI. And on the top of it, or I should say maybe on the bottom of it, we still have GDPR, of course, so we cannot forget about that. And as we all see, the EU digital landscapes keeps gaining complexity, and it can be tricky to understand how these all new laws interplay, how to interpret them, and also how to implement them by companies. And by companies, I don't mean only big tech companies, but also smaller ones, also startups who want to get into the market. So I will give the floor to our panelists, and Berend, if I may start with you. You are a partner in Bird & Bird, and for many years you've been working together with technology-driven companies. You advise on compliance matters. You also focus on the legal aspects around online innovations, and you are a co-editor of the Dutch Journal for International Law, if I'm correct.
Correct, thank you.
So yes, could you please tell us how this complex legal landscape looks from your perspective?
Yeah,
yes,
thank
please,
you.
the floor is yours.
Thank you, Nina, for the introduction, and thank you for having me. And good morning, everyone. Today, I want to talk with you about operating systems. Sometimes operating systems for phones and computers are presented with great fanfare. New features, new applications, more functionalities. I don't know what the average age is in this room, but back then we made the shift from Windows 3.11 to Windows 95, and it was a very notable change indeed. And often after such a dramatic change, you see a more subtle change in the next iteration. No new applications, no new functionalities, no significant changes in the user interface, but instead a focus on the processes under the hood. So the operating system looks largely the same, but it consumes less energy, less memory, works faster, and has small but noticeable improvements that take the overall performance and the user experience to the next level. So Apple, for example, famously marketed its Snow Leopard iteration of macOS as having 0 new features. With that, Apple emphasized that all the improvements were under the hood. Improved performance, greater efficiency, and a smaller memory footprint. So by now you're wondering, why on earth am I talking about operating systems? Well, I see the new data laws as presented by the EU, by the European Commission in the last 5 years, as a new operating system for our digital economy. With new regulations such as the Digital Markets Act, the Digital Services Act, the Data Act, the AI Act, the NIS2 Directive, Cyber Resilience Act, the list goes on. There's a lot of new legislation for the digital space. Of course, a number of these laws are iterations of earlier laws, such as NIS2 and the Digital Services Act. And in that case, almost all of the new they come with a broader scope and additional and more detailed obligations. And there are also brand new regulations, such as the Data Act and the AI Act and Digital Markets Act. These are full of new definitions, novel concepts, and prescriptive obligations, often with considerable room for the European Commission to add, change, or further detail scope and rules. That's nothing new, but this is compounded by the fact that these interact with a lot of other EU laws. And I think it's safe to say that the GDPR is king in that respect. It's almost comical how often the new EU laws refer to the GDPR and state the new regulation is without prejudice to the rights and obligations under the GDPR. That's all very nice, but just merely reminding the reader that the GDPR may also apply generally doesn't provide an answer to sometimes more complex issues. For example, when there is tension between the principles of the GDPR and the respective law. And we've seen that this is not easy when looking at, for example, the open banking saga. The name says as much. PSD2 aims to open banking data up, whereas the GDPR aims to protect personal data, for example, by limiting data sharing. This is not the moment to go into too much detail, but let's just say that after 5 years plus of PSD2 rules, the friction and the discussion around this topic remains. And there's much more legislation, new legislation, that interplays with the GDPR. So these interplays with the GDPR can be relatively easy to spot. When it's about personal data or potentially about personal data, the GDPR can apply. But there are also some less obvious links between the new laws. For example, Article 2.8 of the Data Act defines a data processing service as a digital service that is provided to a customer and that enables ubiquitous and on-demand network access to a shared pool of configurable, scalable, and elastic computing resources. The definition goes on. I won't bore you with that because then I'm out of breath. But what's interesting to see is that cloud computing services under NIS2 have a very similar definition, and by reference also the DMA. And that's something that you should take into account, because qualifying as one might unknowingly have implications for the qualification under the other law. And lastly, there is the darling, the AI Act. As most people in the room know, it is in practice far from finished. It contains more than its fair share of questions and points to be later clarified. And on top of this, it remains to be seen how all of this will be implemented into local law and how the supervision of these laws and rules takes shape. As you can see, there are a lot of rules coming at us from Brussels, impacting virtually all organizations in the EU and beyond. In my experience, the practitioner's experience, as we're talking about today, not nearly everything is properly on the radar of companies and organizations. And in practice, many are staring blindly at AI. And there's simply not enough bandwidth and capacity to assess all of this for relevance in a short time frame and implement it where necessary. With the outgoing von der Leyen Commission, I strongly urge the Commission, and I know they're listening, not to be blinded by all kinds of new gimmicks and features when updating our European digital operating system, but rather to focus on the correct implementation, interpretation, proper guidance and functioning of the existing and just introduced laws. And whatever comes our way, we can rest assured that conferences like this, CPDP, will do their utmost to provide new updates with clear change logs, report regulatory vulnerabilities without delay, and present patches for legal bugs where necessary. And with that, back to you, Nina.
Thank you so much for giving us this solid introduction and the overview of how this legal landscape looks like. So let's continue this journey. And Erika, I'm turning into you right now. You work at Altius as an ICT and data protection managing associate, and you advise Belgian and international clients on a broad variety of law and tech matters, including DSA and GDPR. So could you please now tell us what problems and overlaps do you see in your practice?
I have a presentation. I'm going to stand, it's going to be more calm.
The mic?
Oh. How am I going to do that? Hello? Okay. So I'm going to talk to you today just about a few practical considerations that we've met when dealing with the DSA. So it's going to be quite high level because I can't get into too much detail about, the specific cases, but it's just some of the legal questions, let's say, that have arisen. Yep. Am I pressing the wrong button? Okay, so DSA pyramid, just to remind you all of the new actors that are on the pyramid. We have the old intermediary services we all know about, hosting services, they get additional requirements, online platforms, B2C online marketplaces, the VLOPs and the VLOSs. And for us, most of the questions have arisen as to the qualification of online platforms and B2C online marketplaces. So just as a disclaimer, some stuff may seem very obvious, but it's always in hindsight. When you're going through it, it's not as obvious. So first the question is, okay, what's an online platform, right? So we've come to this conclusion that it's any sort of service that really is focused on user-generated content, right? So it's what people, users can post, and they put up there for others to access and to read. But this has to be the core service, so it doesn't apply to websites because most websites have comments, right? Like a comment section, that's not going to make it an online platform, not in and of itself. So user-generated content, that was our key. And then we started to look a lot at, okay, so when does a platform become an online platform allowing consumers to contract with traders, which we understand is a B2C marketplace, but which was not the terminology used in the DSA. And apparently they chose not to use the B2C marketplace, not to use that term. So then the question, okay, what are distance contracts? And distance contracts are super broadly interpreted. So it's any time there's no physical presence of the two parties, and they use means of distance communication. So what's that? That's like a phone, an email, that could be anything. So you have this very, very broad concept. And what does that mean? That websites where you can post, post ads and it says contact seller, or call seller, write an email, get a quote. Does that mean that, oh, this is an old one. Does that mean that it's a B2C marketplace? We had this gut feeling that it wasn't the case. But gut feelings are not enough in law, so we had to go find some backup for this. And so we started to look in other EU instruments about, okay, where are marketplaces defined? And so they're defined a bit in many places, and one of these places is the Omnibus Directive. So that's about software which allows consumers to conclude distance contracts, but then it refers to two other instruments, ODR regulation and the NIS regulation, which also have definitions of marketplaces, and obviously they didn't want to make this coherent, they're different, right? So how do you reconcile all this? I'll make a long story short. We opted for the ODR regulation, which was also corroborated by other sources, which basically says that an online marketplace, you have to conclude the contract through the marketplace, right? It has to be that it takes you through the entire purchasing process, right? So that's the definition we decided to stick with. So basically now, an online marketplace is where the software itself, you have to put in your card details, you can press purchase, that sort of thing. I mean, it's the full process, which is a bit stricter than what the DSA actually refers to. And then another thing to watch out for if you are a marketplace is that you can't mislead consumers on who the actual seller is, right? Because then there's an exemption to the liability exception, which basically says that the platform is going to be liable for the products, let's say, being sold, right? It's going to be liable from a consumer protection point of view. And so this means that the platform can't say that it's like vetting people or exercises any control over the products, because then you lead the consumers to believe that you're actually playing a role in the sales, right? You control the goods being sold. And it's not enough just to say in your T's and C's, oh, by the way, we're not liable, it's just the third-party sellers. You'd be surprised what you can find on websites. So this was one of the questions that we ran into, which was a bit of a rabbit hole. And the other question that we've been dealing with a lot is the overlap of DSA and GDPR. So obviously DSA regulates some very specific cases of targeted advertising, and then the broader question of what illegal content is also covers personal data. It covers personal data and also like specific posts, right? And removal requests. So let's say a notice and takedown is also when you effectuate a removal request, it can also be considered a notice and takedown. So what are the consequences of that? Well, first we have to sort out the relationship between DSA and GDPR. So DSA says it applies without prejudice to GDPR. So you think, okay, GDPR sort of like, you know, takes precedent. But then further on, you also read that actually the two rules, they overlap, right? DSA is going to apply to everything that GDPR does not specifically directly regulate or leaves to the member states. For example, enforcement, right? That's something that is supposed to be le recours effectif, that's supposed to be organized by the member states. So actually DSA takes on like importance with regard to enforcement and also sort of modalities for the implementation of rights, okay? But those types of very specific things aren't dealt with by GDPR. So what does that mean? There are some consequences in terms of DSRs, data subject to ratio request, how they have to be treated as part of the transparency obligations, reporting, T's and C's, the processes that have to be applied, because there are all sorts of processes. You know, notice and takedown now is like very regulated. It has to meet all sorts of conditions. There's, in some instances, you have to have external reviews and voila, so those processes, depending on the qualification, can apply. And then injunctions, and this is where we've seen it, is that it impacts what you can ask a court with regard to your GDPR rights. I'm not going to get too much into it because that's sort of old news, the no general monitoring obligations. We've seen this before. You're not supposed to ask for, let's say, you can't ask IS services overly broad orders that would require them to have to survey the content that's being continuously uploaded, right? That's not acceptable. There's lots of case law on it. Also, there are now very specific conditions, also even more than before, on what can be asked from a court. And what I think is interesting is that you have this sort of opposition in GDPR where the rights apply with regard to processing activities and a set of personal data, whereas DSA is really focused on what is the specific illegal content at hand. DSA is all about a particular post, a particular URL, right? And so there's a bit of tension there between GDPR and DSA. But basically, in the end, you can't ask, for example, you can't oppose, you can't ask the erasure of, I can't ask the erasure of my name and any mention of, I don't know, where I went to school, where my religion or something. Like, I can't say any reference to Erica Ellen and her family member or something. It has to be very specific to a post and an even more a URL. So these are sort of the questions that we've come across, and maybe in the future we'll see, you'll get the specifics on the cases if they come out. Okay, thank you very much.
Thank you, Erika, for pointing out these different definitions and overlaps. And this topic is getting more and more complicated. So let's move and have a deep dive in this complexity. So Charles, you are head of the EU Data Privacy, Cybersecurity, and the Digital Assets Practice at Squire, Patton and Box. Also a member of the advisory board of the International Association of Privacy Professionals, and a lecturer at University of Louvain, and a founding member of a research group there called the DRAILS, Data, Robotics, AI, Law and Society. So I think with this experience, I'm sure you have a lot to say about other overlaps and things that might be confusing for organizations. Please.
Thank you, Nina, and good morning all. I'm very happy to be part of this important panel, and I want to thank my co-panelists and CPDP. And I'm also very impressed by this new venue, by the way. So it's really a pleasure to be here with you today. As we all know, and as Berend reminded us with great quality, the last European Commission tenure will probably be best reminded as the one with an abundance of D frameworks. And one that had the kind of very long list of unbearable acronyms in the digital world. So Berend tried to capture them all, so I won't try again, but indeed, so DMA, DSA, DA, DGA. I think you didn't quote EHDA, probably, so for the European health data space, let alone AIEA. So all of those are indeed, as Nina mentioned, part of the broader digital strategy. And I think we should really credit the European institution to have managed to deliver on so many files during a relatively short period of time, certainly according to the EU institution timelines. I won't use the operating system analogy, but I'll try to take the D element to the next level. I have tried to make an analogy with vitamin D, which is, as we all know, a group of fat-soluble sexosteroid responsible for increased intestinal absorption of certain substances and vitamins that apparently has many other important biological effects. And you say this guy is completely crazy, so why is he speaking about vitamin D? I think there are two interesting elements in that analogy. So first is that vitamin D increase absorption, and the fact that it belongs to a group, put it simply, of steroids, I believe it's also another interesting analogy. Because those speaks very well to what the new D-regs are seeking to achieve. So for organization companies, big or small, whether they are relying heavily on data or not at all, or not so much, it's really a matter of trying to absorb all of those new requirements coming by waves and sometimes eroding their ability to conduct their activities. And on the other hand, each of those new regulations add to the enforcement toolbox that authorities are receiving to address let's call it between brackets, the data world. And my purpose is certainly not today to judge on how each of those two elements, so absorption and new enforcement, are delivering on their project outcome. But I'd like to give you an opportunity to make your own determination with the contribution I'll have today. And so for that, I'd like to cover two case studies, one for each leg of my vitamin D analogy. And I'll use dark pattern as an illustration of the absorption issue. And I'll use the development around behavioral advertising in relation to the enforcement on steroids. So on dark patterns, to start with, no need to probably remind this audience about what dark patterns actually are and what the deregulation around dark patterns are trying to achieve. You all know that dark patterns are already tackled and addressed by a number of instruments, one around fundamental rights with the GDPR, and one, of course, an important one as well, through consumer protection around the Unfair Commercial Practices Directive, notably. On the GDPR front, we have received very clear guidelines from the EDPB, as well as many other national supervisory authorities on the topic. The guidelines identified 4 key GDPR provisions relevant for dark patterns, and no surprise, probably, it comes from or reminds the principle of fairness, the principle of accountability, one around transparency, and probably important above all, data protection by design and by default, for which, as you all know, we also receive specific EDPD guidelines. Data processing information and option should be provided in an objective and neutral way. That's what the EDPB guidelines are telling us. Avoiding any deceptive or manipulative language or design. And frankly, with that, you could say, okay, we got it covered. We have it all. We don't need more rules than those little principles, because those little principles are already very powerful. And as we know, GDPR authorities have kind of little enforcement right that they use here and there. And so it's probably enough. But it's not all. Because on top of GDPR, we also have in the UCPD, we also have strong language around the fact that commercial practices must not be manipulative. And it's not only that, we also have a commission notice that includes reference as to how dark patterns could be coded by consumer protection, with example of dark patterns, such as bail and switch, false urgency, inaccurate information, falsely describing a product as free, which I believe is an interesting one. All of that, as well, seems pretty future-proofed and capable of covering most, if not all, problematic situations. And as I mentioned, also on the consumer protection side, you also have like strong enforcement capabilities, so you probably have it all. But it's actually not the case, because somehow it was perceived as important that the DSA also covered dark patterns. What does DSA says about it? If you want to look at it, you need to go to Recital 67 and Article 25 of the DSA. And basically, Article 25 prohibits online platform from using dark patterns. It states that providers of online platforms shall not design, organize, or operate their online interface in a way that deceives or manipulates the recipients of their service, or in a way that otherwise materially distorts or impairs the ability of the recipients of the service to make free and informed decisions. That's another layer. And as Erika mentioned, DSA also tells you, don't worry, if it's covered by GDPR, it's covered by GDPR, so there will be no overlap, you will be fine. it's easy. No, it doesn't say that, but you hope it says that. But frankly, it's not that easy, because even if I cannot, like in the 2 minutes I have left, and I still need to cover one example, by the way, so I cannot in those 2 minutes provide and showcase why it overlaps. I can tell you that on the practitioner side, we see a lot of problematic overlap between DSA, UCPD, and GDPR, because frankly, all of those online platforms, they are subject to the DSA because they are online platforms, but they are also processing personal data, so they are also subject to GDPR, and also most of them are B2C, so UCPD is relevant for them. So it's much more a function of how can you operationalize things to try not to breach one, two, or the three of them, which sometimes might be tricky. And it's also opening the door to enforcers about which avenue they will choose to eventually catch you, which creates a lot of uncertainty. So that was my first vitamin D example on the overlap and absorption of multiple layers of digital law. In the 30 seconds I have left, I'll briefly comment on the other one, which is the enforcement on steroid, and so using behavioral advertising as an example. I'm not sure if you managed to track the number of cases, and for each of them, the authority and the length of the procedures that social media platforms have faced in relation to behavioral advertising. I didn't do the math, but there is clearly no doubt that there are many on a number of different bases, so GDPR, DSA, DMA. And in GDPR alone, you have wave after wave case requiring organization to shift legal basis, up to a point where you almost have no legal basis at all. And I'll conclude by saying that for me, the most problematic encounter that we had was the recent payoff okay opinion of the EDPB under Article 664(2). And it's not so much problematic about for what it is stating, but we can open that to debate. But it's even more problematic because it shows how one EU institution was weaponized to enter a debate that wasn't probably made for it, meaning that we have no really enforcement on steroid, with enforcers that are not enforcers that are stepping into debate that they shouldn't be really entering to. And with that, I thank you for your attention.
Thank you so much, Charles. Yes, dark patterns are very, very illustrative examples to show the overlapping issues with these three different regimes and uncertainty around them. So we heard a lot about interplay between different legal acts and great examples. And by the way, in the Netherlands, we really need vitamin D absorption. So now let's take an angle of contracts, because this is also the important area where the new laws have particular implications. And I would like to welcome Caroline. She is an attorney based in Brussels, working as a senior associate at CB law firm, and she also specializes in the new technologies, data, privacy, e-privacy, media, software licensing, e-commerce. So Caroline, could you tell us how this new legislation will impact contracts and contracting practices?
Yes, certainly, I will. Thank you all for joining us at this panel this morning. As Nina introduced me, I'm a lawyer in Brussels in a technology practice group. And so I'm regularly involved in contract drafting and contract negotiations. And so for the topic of this panel, I thought it might be interesting to have a specific look at what the new acts mean for contracts and for contracting practice in general. And I have identified 4 themes, 4 areas where we will see such an impact that I will briefly explain to you together with some examples. A first way in which the new acts and the new regulations will impact contracts is that we will see new types of contracts. Because the new acts, they have introduced a lot of new labels and a lot of new actors, players, and they even paved the way for new types of services. Some of the speakers have already addressed some of these new labels, but to give you some other examples, the Data Governance Act, for example, the DGA, has introduced the concept of data intermediation services. And those services we haven't really seen before, so we expect to have new contracts relating to those players on how these interact with, on the one hand, the data subjects and the data holders, and then on the other hand, the data users. So that will be something new, as we haven't seen much of it before. Another example comes from the Data Act. Under the Data Act, users of IoT devices or connected devices are given more control over their data. And so they can choose to share the data that are generated via their IoT device or their connected device with third parties who are not the manufacturer of the device itself. And what we also expect to see on that front is that those new third parties will be able to provide more innovative data-based services, again, services that we haven't always seen before. So that will be also an interesting angle in the data market. And so what does this mean for us as a practitioner? Of course, we need to keep track of those developments. We need to be up to date on it so that we are able to draft contracts that are suitable for dealing with new types of challenges and new problems that these new types of services may bring along. To give you an example on that front as well, in IT contracts, more traditional IT contracts, think about outsourcing contracts, provisions relating to data in those contracts were mostly only limited to personal data. So usually we would see some provisions relating to GDPR and the mandatory provisions specifically you need to include in your contracts to ensure compliance with GDPR, but that was about it. And now with the new types of contracts that we will see, data will actually become the subject itself of the contract. And so we will need to include much more provisions relating to, for example, access to data, like who can have access, what types of data, at what level of detail do we need to grant access. Think about the use of the data. Do we need to tie restrictions to certain purposes, as well as for the onwards transferring of data? Do we want to tie restrictions to that? What about responsibility for the accuracy of data or the quality of data, and so on? So we will see new types of provisions, and we will need to have a much more focus on data compared to some of the more traditional IT contracts. So that's a first way where we expect to see some influence of the new acts on contracts. A second one is that with all those new acts, we as legal practitioners are, of course, faced with more restrictions on the contractual freedom, also in B2B relations. And those restrictions mostly intend to protect the weaker party in B2B relations against potential abuse by the party that has a stronger bargaining position, similar to what we have had for consumer protection for a long time, but now also in B2B relationships. And one example thereof is the Data Act, of course. In the Data Act, you can find a list of clauses that are considered unfair. There's a blacklist and there's a gray list. The blacklist meaning that those clauses are considered unfair in any event, whereas for the gray list, you can still try to demonstrate that the clause is fair considering the circumstances of the contract. There's not only restrictions that aim to protect the weaker party, there's also some provisions that really try to foster competition and that want to enable the reuse of data for innovation. And some of these examples can be found in the Data Act as well, in the rules on switching between cloud providers. There are rules whereby the providers of cloud computing services need to facilitate the switching, and so that means they also need to remove any barriers in their contracts that would impede such switching. So that's another restriction that's really aimed to foster competition in the cloud markets. Another one can be found in the Data Governance Act, in the rules on reusing certain protected data that are held by public bodies by private entities or by other public entities. And there, in those rules, there's also a provision that it's not allowed to grant exclusivity to a party for reusing the data, because they want to open it up as much as possible, and they want to allow the reuse of data also by other parties. So again, a restriction that's aimed at driving innovation. Again, what does this mean for us as a legal practitioner? Of course, we need to keep track of those developments. We need to be aware of it when we are drafting and negotiating contracts to make sure that our client or our company ends up with a lawful contract that can be enforced afterwards. So that's the second development I wanted to cover. The third and the fourth one I will cover more briefly. The third one is that we see in all the new instruments a lot of provisions relating to terms and conditions. So there's a lot of new rules that prescribe the content of your terms and conditions, and even the format, like how they should be accessible, that there should be a summary, even in which languages platforms should communicate these terms and conditions. There's examples in the DSA, in the Data Act as well. Even in the platform to business regulation. I think that's one that we haven't covered yet. It's a regulation from 2019, also dealing with online platform and also including a lot of provisions to take into account when you are drafting terms and conditions. So again, as a legal practitioner, we need to keep track of everything. It might be useful to create some checklists to make sure that we don't miss anything when we are reviewing terms and conditions. And then the fourth development relates to model clauses. So model clauses proposed by the European Commission. We have known model clauses for a long time in the field of personal data in the GDPR for transferring data to third countries. So we know the standard contractual clauses for quite a long time. I think it was in 2021 that the Commission also adopted model clauses for data processing agreements, so under Article 28 GDPR. And now with the new acts, we expect to see more of those model clauses. For example, under the Data Act, the European Commission is working on model clauses for cloud computing contracts and also for data sharing contracts to help market players to come up with fair and balanced data sharing agreements. So we will see much more of those in the future, which might also be helpful for legal practice. So for the time being, that's all I wanted to say, but happy to answer any questions later on.
Thank you so much, Caroline. This is a super interesting talk, and sounds like a lot of work for you in law firms. So we have heard a lot of burning issues already, but I think we are still missing one, which is the enforcement. And I would like to give a floor to our last speaker, and after this talk, we will have a Q&A session with the audience, so if you have any questions and comments, there will be time to do that. So I would like to give a floor to our last panelist, is Laura Brodel. She works as a senior associate in the EU data regulatory practice at Wilson Sonsini in Brussels. She's recognized in the Legal 500, and in her practice, she regularly provides practical guidance for tech sector concerning financial technology, gaming and entertainment, biometrics. So Laura, you have a deep expertise in navigating regulatory investigations for your clients. So could you tell us how the new digital laws will be enforced?
Yes, happy to. Firstly, I apologize for being all bandaged up. My official story is I was so surprised that the AI Act got adopted and I fell off my chair, as we say in Dutch, and that's what I'm sticking to. Now, separate from that, talking about enforcement. I'm very happy to speak about that, and I think it, as you mentioned, naturally flows with what all the other speakers have touched on, is this complex risk landscape that we face that inevitably we'll also see in the enforcement. That's why when I was asked, Laura, can you present some slides, there was only one image on the internet that came to mind to appropriately describe the enforcement framework. Now my lovely face is there instead of the meme, but it's a meme of someone who is trying to navigate this web of, oh, there we go, this web of different pieces of information and trying to find one solution, having to frustratingly realize there is none. And that has been my experience with enforcement, and inevitably will also be the experience both on the regulatory side and on the company side in dealing with enforcement. Now, just to give everyone a little flavor, we've mentioned various digital acts here today, but those are only a few. In total, there are more than 15. Yes, 15. And they're all digital acts, meaning that they are going to apply to a broad part of our current economy. I think that there are a few companies out there that will not be subject to at least one, think of GDPR, or more of these acts. Then these acts have various enforcement authorities. You might be dealing with the Commission, you might be dealing with a national authority. The national authority could be a data protection authority, telecommunications supervisor, audiovisual supervisor, competition authority. So again, a patchwork there. And then amongst themselves, they will also have to determine who is competent. So you can already feel the puzzle. If you were to put all of this in a scheme, you're probably going to end up on my meme. Then, apart from who is going to enforce, there's also a big range in the sanctions. The lowest is 2% of your annual turnover, but it ranges as high as 10%. So a lot of people get nervous. You know, we don't need to beat around the bush. If we're talking about that potential scale of enforcement, we're also talking about the viability of companies to operate, and we're talking about livelihood. So we're talking about very stressful situations. Now, I'm sure that there are people in the room that will say, that's all great, Laura, but many of these are not yet enforced, so why are we talking about enforcement? The reason I think it's important is because the best remedy is preparation. Not only making sure that you have mapped everything and you know what the risk is for you, who you need to talk to and when, but also making sure that your company and your staff are ready. And I'm sure that doesn't only apply to the companies. My first point here is the crossover activities. Not only for companies, but also for regulators. More work for everyone means more resources, more assessments to be made on both sides. As I mentioned, various authorities, they will be the ones to initiate the investigations. They'll have to assert their competence. They might have to deal with other authorities and figure out who is competent and make sure that that assessment is stress tested, because companies will potentially challenge their competence. And on the other hand, companies will need to assess if someone is asserting competence, if that is actually correct. So you can already see the crossover and the resource intensiveness that people should be ready for. Then practically, we also need to realize that a single incident, activity, or event could trigger investigations by multiple authorities. And they might all be competent. And you might have to deal with these at the same time or several years following one another. We've seen that with GDPR and cybersecurity issues. Doesn't necessarily all happen at the same time. If it does, it's quite similar to the Oscar-nominated movie Everything Everywhere at Once. I can tell you, it's stressful, again, on both sides. If it doesn't, it is still something that your company needs to deal with. People leave companies, but they might have been staffed on a project, attained all the knowledge, and then they have to transfer that to someone else who then has to deal with the follow-on investigation. Those are all practical elements of cross-border investigations. So we know now there are coordination challenges, both regulatory and at companies. But then we also have the stickiness of local procedural rules. And that is a fact of life. It is something that I'm sure we'll see pop up often when the Commission is dealing with an issue versus where a national authority is dealing with an issue. Anyone who's been in some way in touch with GDPR enforcement must have felt that it can get tricky, that national procedural laws may prescribe or differently interpret how to respond to an incident, to a complaint, to an individual. So first, coordination challenges. Second, realizing that these laws, that many of them still have to enter into force, or that there's a grace period, will likely see a phase of testing the waters. And I don't mean a free-for-all for mavericks to go ahead and do whatever they want and get away with it. I don't want anyone quoting me as a lawyer saying, you can just do what you want during the grace period. What I mean is that in a vacuum where there is no interpretation of these rules yet, companies still have to operate. They still have to navigate their business. So they will implement practices depending on how they operate those practices. They might proactively reach out to authorities and stress test them. And in other cases, they might simply become investigated and have to amend their practices. But that is a phase of testing the waters that we'll see. And I don't expect that it will be different here than what it was with GDPR, the first NIS, etc. And then a last element that I personally just wanted to emphasize is the value of project management and respectful communication. I know it's a tricky world out there right now, but I would imagine that those are two skills that anyone dealing with enforcement on either side will have to be able to master. Project management, knowing what's happening when, who's talking to who, what have we said, what have we not said, are we on top of all the deadlines, and then also respectful communication. You don't have to like who's on the opposite side of the table, but you have to respect them and be able to talk to them. We don't all have to agree. We might challenge your position, you might challenge ours, but let's find a way to talk to each other. I personally just want to put that message out there in a very contentious world. There needs to be a way to make everything operational, and I do think that's an important skill. So in summary, I would expect coordination challenges and crossover investigations. I expect we'll see a phase of testing the water, and let's not underestimate the need for project management and respectful communication. Thank you.
Thank you so much, Laura. That was an applause at the end, but we still have Q&A session. I think we can have more and more examples about this topic. This is like an endless topic, and as Laura said, we have more acts that we just mentioned here. So we are already aware that this is only a tiny portion of this huge topic that can be, I can imagine, 1 year academic course or even longer. So I would like to open the floor for questions from the audience. If you have any thoughts or comments or, yes, questions to our speakers, please raise your hands and introduce yourself. I can't imagine that there are no questions from the audience. Yes.
Good morning. My name is Erik Valgaard. I'm also a lawyer based in Brussels. I have 2 questions, maybe for the 2 last speakers, but the first one for Caroline. With everything you said about the impact on the contract practice, what will be the room left for creativity for us lawyers, and will it still be fun to do contracts, listening to all the points you need to have on your checklist? So that would be my first question. And the second question, maybe with respect to the enforcement, which authority or which side do you think, you mentioned a few potential authorities that would step in, DPAs, telecom regulators, competition authorities. Where do you expect the heat to originate first? That would be my question, if I may. Thank you.
Thank you, Erik, for that question. I think with respect to contracts, indeed, as I explained, we have more restrictions on the contractual freedom in B2B contracts. that we need to monitor, but there's still a lot of room for creativity, so contracting will still be fun. It will especially be fun to test the boundaries of where those restrictions start and where they end. To give an example, I talked about the blacklist in the Data Act, but there's also a gray list. And for the gray list, a co-contracting party can still try to demonstrate that the clause in the circumstances at hand is still fair. And there especially, there will be room for creativity, for trying to find circumstances that could support your position that the clause is fair in that specific case. I expect to see some case law around the topic as well that we will have to monitor, but it will be fun, I think, in trying to find, which leeway especially still will exist. Yes.
Thank you, Eric, for the question. As to where the heat will come from first, I would say the Commission. And I think based on the conversations I've had, that is much appreciated also by national authorities because they do have some guidance from up above. Now, in practice, I'm sure some people will think it's like in American movies where you have several law enforcement agencies and then the FBI comes to the scene and then everyone's disappointed because they have to hand it over to the FBI. That's not how it goes with the Commission. But similarly, they do have a lot of experience with cross-border enforcement. They have experience with dawn raids. They have experience with their own specific procedural rules. So it's very easy for them to hit the ground running. And that's where, in my practice, I've seen the quickest action following these laws. In terms of national authorities, I know that the cybersecurity enforcers are very eager. They have seen a significant increase of cyber incidents in the pandemic, and it concerns them. So I know that they're very eager to start asking questions. If you look at NIS2, which also allows for proactive enforcement and audits for essential entities, I think that's where, if you're in that area, you might expect some questions pretty soon. On the DSA front, because the Commission is very active, I've seen national authorities focus on guidance and talking to companies. If there is an initial wave of enforcement, there seems to be a lot of focus on misinformation, especially with a lot of elections coming up in the EU, and potential risks for democracy, which I don't think any of us could question at this point. DPAs will continue to roll in waves as they do. They're starting to target their enforcement more in certain industries, trying to set standards not specifically for companies, but really for groups of processing activities in the hope that that sets a standard more beyond their own country. Then let me think if, in the area of AI, I think that is where we can put my meme back on the screen. There's a lot of discussion on how that will actually work in practice. But I would expect that several DPAs have made the link between GDPR and AI and are trying to engage in proactive conversations with companies that develop AI specifically. Not necessarily the users. I'm not saying that they shouldn't expect any questions, but I would imagine the heat is primarily on the developers at this point.
Thank you. Are there any other questions from, yes, please.
Thank you. My name is Anne McCormick from EY. I'm Global Digital Policy Director. I'm interested in I'm not a lawyer. I'm interested in your perspective as lawyers who work on specific cases with specific challenges, interpreting the law, but also realizing that the law itself is still patchy and complex. Looking at the next commission and the focus on implementation, where do you see the most urgent need for focus in providing greater clarity, not necessarily through cases and individual disputes, but in dialogue with the Commission, with the Council, but also with the national competent authorities? What would you prioritize? Maybe asking Laura and Bernd for a start. What's critical and urgent? Because the technology is moving very fast. We don't have 5 years of case law to observe.
Thank you for a good question. I think that's a question that a lot of companies are asking themselves too. What help do we need from a body like the Commission to clarify things that are currently not clear? I would think two regulations, if I have to name two, the AI Act, because let's face it, it's not finished. It was a political deal that needs clarification. For example, if you're modifying or fine-tuning a general purpose AI system, there's a risk that you yourself can become a provider, and it's very unclear when you actually change color. So when you do become a provider of the AI system with all consequences that it comes with. So that's one. And I also think that as ambitious as the Data Act is, that act has a lot of implications for data sharing and very commercial implications, because all of a sudden certain business models are no longer available or at risk for companies, for better or worse. I mean, there are agricultural companies which have a monopoly on the data generated by your agricultural devices or machines. And yeah, they've relied on that for a long time as a source of income. The European Commission found that that was imperfect. But it does mean that that's going to change very rapidly in the next coming years. And I think that's just one example. The Data Act is technology neutral to a large extent, at least for that part, by the way. So I think there's a very urgent need for guidance there too, and it's extremely ambitious. So we'd have to see how the next Commission is going to continue to work on the Data Act and the various data spaces, and we'll see after June 6th. Thank you.
And I can definitely echo the points that Berend raised, especially on the Data Act. We see similar discussions with FIDA, which is the financial specific version of the Data Act. Another one that I often see is about NIS2 and how this registration model for essential entities will work. That there's a lot of ambivalence about, do we need to proactively reach out? Will they reach out to us? How will the registration system work? That's another practical one that I can think of. And then I would say, more generally, I often find that companies are looking to have a conversation about how their product or business model really works, rather than going off of an assumption of how it works. So trying to have the opportunity to present the product, to come to the showroom, see what the model is, how it operates, sit in it, hold it. Let us explain to you how this technology works. It's not necessarily what the media portrays that it is. Let us show you, and then we can have a conversation. We would be happy to answer all your questions. I know that's not a clarification of an act, but it's something that I often find comes up in practice, is making sure that people understand the product, service, or business model.
And Charles, would you like to refer also to this question?
Yes, just a very quick point from me on that one. So first, my plea is no new rules, please. So we probably need to digest all of what we received. And like pretty much in alignment with Laura and Berend, I really think that the Data Act is probably one that got slightly unnoticed during its little journey. And it's one that is, I believe, very poorly drafted, which makes the life of companies really, really tough and complicated. And like almost surprisingly, I'll confess, we receive like really many questions on it, and it goes like from scope to implementation date. All of those things should be like clear cut in a new law, but even like those basic things are very complicated to navigate. So, and I don't think that we are supposed to get many guidelines from the Commission on the Data Act, but if there is the ability to have it somewhat, I would probably love to receive some, yeah, indeed.
And Erica, would you like to also refer to this question?
I think the most important has been said. I think one of the main issues would be about under the Data Act, the confidentiality, the trade secrets, because that's still very unclear. Well, no, that's it.
Thank you so much. Are there any other questions from the audience? We still have some time to discuss. So I have one question to Caroline. Because you cover contract laws in different acts, and what about the AI Act? How the AI Act will impact contracts?
Yes, indeed. I didn't touch upon the AI Act because there's a lot to say about the AI Act and contracts. I think the other speakers have already clarified that the AI Act is still unclear on a lot of fronts, and so especially that unclarity will make contracts very important between all the different players in the AI chain. So under the AI Act, we have the provider of an AI system, we have the importer, we have the distributor, and so contracts between all of those will be very important, especially to cover the gaps in the AI Act or to even shift some risks contractually. And so one example in that respect is, for example, the definition of a provider of a high-risk AI system is defined as someone who either provides an AI system that it has also developed itself, but also a provider that has it developed by a third party and then places it on the markets. And that provider will have the main obligations to ensure the AI system is compliant with the requirements under the AI Act. But some of the requirements relate to the specific design. So in the contract between the provider and the developer or the designer, it's important to also include the requirements that are under the AI Act and to shift it to the designer to make sure you as a provider have back-to-back coverage on those requirements.
Yes, thank you so much. And Charles, I also have one question to you about dark patterns, because you covered this topic and the challenges between DSA and the GDPR. So maybe that's a more provocative question. So do you think that DSA adds something additional to the dark patterns, or not?
Yeah, so thanks Tina, for that one. As you probably got from my little introduction, so I'm not entirely sure that adding that addition was completely worth and necessary. And I think there is that tendency, certainly in the EU bubble, to when new pieces of legislation are being in the motion, like every new piece is one that is supposed to be serving as the sparadrap for things that were not working in others that you cannot change. And I think that's really a pattern that hopefully we will see changing, because I believe that creates a lot of unnecessary complexity. So moving from dark pattern to behavioral advertising, if the issue is that behavioral advertising shouldn't exist, let's just say it and let's just ban it. But trying to get to the same outcome through a new piece of law, case law, DPA authorities, etc., I don't think it will help us greatly.
Yes, that was the sign that we have only 4 minutes left to the end of this session. I'm also wondering, because this is the European approach, that we have so many regulations. And I know, Bernd, that you also know companies from the outside of from Europe. And could you tell us how this legislation work is perceived by the non-European companies?
Yeah, I'm going to be very cynical. It's not perceived well in 2 different ways. One is it's not on the radar. I mean, everybody's talking about AI and the AI Act. There are some companies who are aware of the DSA, more than some, but still the DSA is also on the radar. But after that, yes, people talk about cybersecurity, but NIS2 is now... We've had NIS2 already for quite a while, and now it's starting to become out of the limelight and get into, let's say, the minds of the counterparts in the US. But things like the Data Act or even the Data Governance Act, those are hardly on the radar of companies, or many companies in Asia and Japan, China, in the US. And that requires a lot of work on our end, because we don't want to have them faced with data requests the moment, for example, the Data Act comes into force, and them saying, well, why didn't you warn us? So I remember 2 years ago when all these data laws were introduced, we were giving presentations where we covered all of the Data Acts. Well, we've learned very quickly that that was too much. It was too much for us, and also too much for even European in-house councils, but definitely Japanese or US or Chinese in-house councils. They want to have very concrete examples of how it can apply to their business. And we really need to digest it for them. Still, everybody now wants to talk about the AI Act. And it is very important, but it's not the only thing that's out there. And I think I've made that point already, but the Data Act and other acts are equally as important, especially now.
Yeah, thank you so much. We still have time for one questions from the audience. So if there is any final comment or question, there is a time. I don't see anyone. So can we have like one sentence of concluding remarks from each of you, like really briefly, like what should be the conclusion of this talk? Maybe we can start with Laura from that side this time.
I think my sentence is what's on my shirt. There's beauty in simplicity.
Thank you.
I will end with saying that we have a lot of job certainty as legal practitioners, because there's a lot of questions still open. So that's good news for us.
Yes, thank you so much.
I know there are some people who are a bit concerned about AI, but I also think that we really need tools like AI to process and digest all of this new legislation. So.
Thank you.
I'll just say good luck to us all. So.
Yeah, I'll just say that it's quite fun, actually, as a lawyer. So it makes the job interesting.
Thank you so much to our speakers today. I think that the complexity is really visible, and our speaker will be here also during CPDP. So if you want to reach them out, they will be here around. So thank you for your attention. Thank you for the questions, and give a big applause to our speakers. Thank you.